Hi, good afternoon, everyone, and welcome to this Society of Labour Lawyers webinar. And thank you so much for coming along this evening to discuss this incredibly important topic, the end of the evictions ban, which was in force for a little over 1 year. And we're really pleased to have Marina Sergides and Simon Mullings on the panel. Simon's going to join us very shortly because they're probably the best speakers it's possible to have on this subject. Simon and Marina are the co-chairs of the Housing Law Practitioners Association, HELPA. And, excuse me, HELPA is one of those things that we never quite realised how useful it was, how crucial it was, until the pandemic came along, because all of a sudden we needed courts and policymakers to do unthinkable things. And HELPA and Simon and Marina in particular worked incredibly hard and incredibly quickly to make the case for an evictions ban and for a safe environment for court users. And they've then carried on working incredibly hard throughout the pandemic to ensure everyone's well-being. And as frontline professionals, as housing lawyers, they're very, very well placed to tell us what we can expect to see over the next few weeks and months. We're going to have Marina speaking first for about 15 or 20 minutes, and then Simon when he joins us, and then time for questions. Please do send any questions through the Q&A function. There'll be plenty of time afterwards. And apart from that, Marina, I think it's over to you.
Thanks, Nick. Evening, everyone. I'm going to try and share my screen with you. There we go. It worked, to my amazement. Right, I do have a paper, and it should be in front of you. You should all be able to see it. I'm not necessarily going to stick to it word for word, but it just sets out some of the issues that I'm going to talk about. So the title of this seminar, of this talk, is "Can we expect tsunami of possession orders and evictions? What effect will that have on homeless services and on individuals?" Well, the first of those questions, can we expect tsunami of possession orders and evictions, is difficult really to answer. We certainly expected a tsunami of possession orders and evictions when the pandemic started. I think it was a very real concern. It was a legitimate concern, and it was a concern that I think was met with some response, and I'll talk about what that response was in a moment, but it was met with some response from the government, knowing, of course, that if there was a tsunami of evictions, it would be a public health issue. I have to say the impression I certainly got was not this genuine concern that suddenly there would be thousands of people who would be homeless, but more that there would be thousands of people who would be homeless on the streets and possibly spreading the virus. And it was certainly the latter that the government was more concerned about. There was then, at the start of the pandemic, a series of steps that were put in place. The first was, of course, there was a moratorium on possession orders. And I think it is important to say at the outset, there is a distinction between a moratorium on possession orders and a stay on evictions. They are different things, and they happened at different times in the course of this pandemic. So I set out a very, very brief timeline at the beginning of my paper, which is in front of you. There was, at the very beginning of the pandemic, as I say, a moratorium on possession orders, not on evictions. So, of course, as many as you will know, one cannot evict a tenant until they have a possession order. So the first step in that process could not be pursued, say for exceptional circumstances, say for certain circumstances that were set out. Again, at the very beginning of the pandemic, Secretary of State for Housing at that time said that no renter who has lost income due to coronavirus will be forced out of their home. That was a clear statement. It was a statement that certainly we at HELPA kept referring to. It was a statement that we said formed the basis, or at least should form the basis of all policy in respect of how one deals with what was likely to be the tsunami of possession orders and evictions. It was not necessarily a statement that was followed through in its entirety. So going back, there was a moratorium on possession orders, and then as things progressed, that was lifted, and there was a moratorium on evictions. From the 1st of June of this year, some weeks ago, evictions can resume, and the courts can not only grant orders of possession, which they have been able to do for some time, but bailiffs can follow through on those possession orders and evict tenants. So the question to can we expect a tsunami of possession orders and evictions, the jury is still out. We know from the statistics, certainly that I've seen recently, there is a significant reduction in the number of possession claims currently going through the courts. That is even after landlords were entitled to commence possession claims from December 2020 onwards. So there has been a reduction in the number of possession claims going through the courts. What is the reason for that reduction? Well, I think that the first is obviously the moratorium, but it's also because of the changes, and I'll come on to that at the bottom, in respect to notice requirements. There are extended periods to the notice requirements, both in respect of possession proceedings brought under section 21, which some of you may be familiar with, and in respect of the notices under section 8 of the Housing Act 88. So that did have, I think, an impact on the number of possession claims going through the courts. Those notice requirements are still in place. The extension of those notice requirements was still in place. So, for example, in respect of notice of seeking possession under section 21 of the Housing Act, which would ultimately lead to a mandatory order if the requirements are met, namely notice requirements are met and all the other requirements, that has been extended to a period of 4 months as opposed to 2. So some of those are still in force. Going back to where we are now, I should also say that in addition to the notice requirements, the overall arrangements were also put in place. The overall arrangements, essentially a set of arrangements which were put in place by the Ministry of Justice, essentially looking at how possession claims are to be pursued through the courts, what sort of priority are to be given to different types of possession claims, what information landlords should give the court when issuing a claim for possession, and so on. So, as I say, various steps were put in place. Some of you will also recall that over the pandemic period, there was a slight increase to the universal credit amount of £20 per week. And there was also a slight increase in the amount of money that local authorities got for discretionary housing payments. Discretionary housing payments were introduced to essentially address the shortfall between a person's benefit and their rent, I would say largely because of the restrictions imposed from the benefit caps and because of the reduction in benefits brought in by universal credit. So these are all factors, these are all relevant factors that partly explain why we did not, over the pandemic period, see a tsunami of evictions. That will change. That is changing. We know that the £20 increase to universal credit is likely to go in September of this year. We know that there has been a significant reduction, or likely to be a significant reduction, in the amount that local authorities are given in respect of discretionary housing payments. And we also know that landlords are still entitled to evict tenants on the basis of mandatory grounds for possession. Namely, they are entitled to evict tenants where there are 8 weeks worth of rent, or where they have served a section 21 notice. And in those circumstances, the court does not have discretion not to grant an order for possession. So the sort of tampering on the sides, if you like, all the things that have been introduced to delay the granting of an order for possession are slowly coming to an end. And all the things that would actually stop an order from possession being made, as I say, such as the mandatory grounds for possession, haven't been touched at all. So going back to the question, are we likely to see a tsunami of possession orders? I think that we are more likely to see that going forward than perhaps we expected over the pandemic period. And we're more likely to see that going forward for the reasons that I've said. Why is that a worry? Well, because if we look at this very helpful statistic here, which I found at the Child Poverty Action Group website, we can see an increase in the number of people who are reaching the benefit cap. We can see that over the pandemic, so many more people sought or claimed benefits. And we know, and I don't think this can be disputed, that the majority of people claiming or seeking assistance as homeless are those who have been evicted following a mandatory order for possession by way of following the service of a Section 21 notice. So this is not rocket science. This is quite obvious and quite clear that the more difficult things are for people, the greater or the increase in number of possession orders and the increase in the number of homeless applications that are being made. So as I say, although I can say from statistics that I have seen that there is a reduction in the number of possession claims going through the courts, it is likely that going forward we will see a significant increase in the number of possession orders being made and a significant increase in the number of people claiming assistance. So what else has the government done to try and resist, to try and stop that from happening? Well, what it says that it's doing is to introduce something called mediation, which we are all very familiar with. The government is very keen on all forms of ADR. The government is very keen on mediation in the housing context. As many of you will obviously know, mediation is meant to be an impartial process where the parties come together to reach a compromise, which they may not be entirely happy with, but nevertheless is one that they can live with. The mediator is entirely independent, and the mediator doesn't necessarily have to be trained in the relevant area. In the housing context, the Ministry of Housing and the MOJ have come together to introduce the concept of mediation at an early stage. The idea is that the parties can come together before proceedings get to any sort of substantive hearing and can try and work their way through. It's all very unclear. We don't know what the government considers to be a successful mediation scheme. It's a pilot at the moment. So, for example, we don't know if there is likely to be an increase in possession orders made at the end of that mediation, at the end of the mediation pilot, or if there will be a decrease in the number of possession orders made at the end of the mediation pilot. We don't know. We don't know if an increase or decrease in possession orders will be considered a success or a failure by the Ministry of Justice. We don't know. But what we do know is that there are some difficulties with the way in which the mediation pilot scheme is being rolled out. Firstly, tenants are not currently legally represented during the mediation. Secondly, they are not given specific advice solely for the purposes of mediation. So at the moment, the way in which it works is that if a duty advisor considers that a case is suitable for mediation, and again, that's not necessarily defined, although Simon, who has joined us, can say a bit more about that, as Simon is a duty advisor. So once the parties are referred from mediation, then off they go. There isn't really a mechanism at the moment whereby a tenant is able to then ring their duty advisor back up during the mediation or immediately after the mediation, or indeed immediately before the mediation, and say, look, I need you to give me very specific advice about what it is I'm being asked to compromise on or asked to agree. There is some discussion about whether that should be the case going forward, but at the moment, that is not the position. Secondly, housing is complicated, as no doubt many of you will know. It's difficult for lawyers to get their head around, and orders can't always be made by agreement of the parties. Quite often the court has to be involved and the court has to reach findings. So there is room for mistakes to be made. There is room for tenants to be agreeing to things that they should not be agreeing to. And there is room for tenants to be agreeing to things that will have serious consequences for them going forward. So there is a concern about the way in which the mediation pilot scheme is being rolled out and the way in which tenants are expected to use it. There is further discussion about how it's going to change, and Simon and I are on a working group that discusses this. In fact, immediately before this talk, Simon and I were in a meeting on this very issue. But at the moment, this is how it operates. Will it reduce the number of possession claims going through the courts, and will it reduce the number of possession orders being made? I don't know. At the moment, there hasn't been a huge uptake of it. I'm not entirely sure as to why there hasn't been a huge uptake of it. And again, Simon might be able to say a little bit more about that. But even if there was a huge uptake of mediation, and even if all tenants said, well, okay, we really like the idea of mediation, we really don't want to go to courts on a possession claim in weeks to come, it's not entirely clear how the majority of mediations are going to be resolved, or what the outcome will be. So again, going back to the question of this seminar, are we likely to see a tsunami of evictions going forward? I think there will be a huge increase of the number of possession orders being made. I don't know to what extent, but there certainly will be an increase. And it's not clear at the moment to what extent the pilot mediation scheme will have an impact on those figures, if at all. So that's what's been happening to address the potential increase in the number of possession claims going through the courts. There is nothing from the government going forward other than, as I say, the mediation scheme to address the likely impact of possession claims over the summer and going into the winter period. We know the furlough scheme is coming to an end in September, I believe. We know that the eviction ban was lifted in June. And we know that there's been nothing in terms of the primary legislation that will stop landlords from pursuing orders for possession. So that's what we do know. We don't at the moment know to what extent it's going to have an impact. So that's what I want to say for the time being. I'm going to let Simon say a few words now. As I say, Simon is a duty advisor, so he can say something about what it's been like on the front line.
Thanks so much, Marina. That's really troubling to hear, but obviously very great to have your insight and experience. Simon, are you there? Brilliant. I'll pass over to you.
I'm here. Can you hear me all right?
We can, thank you.
Great. I'm going to share a screen in the vain hope that you're not all staring at your phones or other tablets or laptops for some sporting event, apparently, that's going on. But let me see if I can get my screen shared now. How's that? Is that all?
That's working fine. I can see that.
Fine. Great. Okay. You've heard from Marina perhaps a bit of the substance behind what has been going on. I'm afraid I'm going to go a bit into sort of process here, but I think it's important, and I'll try and pick up on some of the points that Marina's made as well. I think it's important to see where the process of possession proceedings is going to an extent, because I think, well, it's an important and integral part of the whole thing, really. So we know that there are changes coming down the line in relation to possession proceedings, because although it was hidden away, it is actually there at page 113 of the Queen's speech. So going along with the tectonic speed of the Renters Reform Bill, along with that, it's said that the government will explore improvements and possible efficiencies to the possession process in the courts to make it quicker and easier for landlords and tenants to use. I think you could probably delete the word "and tenants," because the cry for this is coming from landlords. A lot of ministers in the government are landlords, and they certainly have very close links with landlord-based organisations, and those organisations have been in the government's ear about possession proceedings for an awful long time, because they're not really very keen on there being due process to somebody being evicted from their home, and they would very much like it to be quicker and much more convenient for them. So this is a dangerous time. The Renters Reform Bill purports to have some tenant-friendly elements to it, and its very title, I think, is supposed to give the impression that it's directed towards the interests of renters. But I think, you know, I don't think there's many people who really think that that's the way in which that bill is going. So what then is due to happen next? Well, possession proceedings are up and running. They have this rather strange shape whereby there is a review date where judges don't do anything apart from look at the papers, but there is an opportunity for tenants to get a piece of advice from a duty advisor such as me or any of my about 107, I think, colleagues up and down the country delivering duty advice. That's not the number of people, it's the number of schemes that are running up and down the country. Those cases then proceed to a substantive hearing where a judge will make decisions as to what happens in the case. The review date is a very important, integral part to the new arrangements that were introduced as a result of the pandemic and following the stay on possession proceedings. Unfortunately, though, they are not popular with judges, and it seems, we learn in the meeting that Marina and I were in this afternoon, it seems that the review date is dead and will be at some point in the future just quietly taken out the back and shot, I think. It's the judges, I'm frustrated about that because I think the judges have not really understood where the review date sits in the whole purpose of the overall arrangements, which, don't get me wrong, there are flaws definitely there, but there are also things that are helpful for tenants and borrowers, and the review date was certainly intended to be one of them. My frustration is that it is being done away with without actually, I think, a proper understanding of where it sits in the whole piece. But we'll perhaps come to that later in discussion. So the idea now is what happens next. There is no real appetite, as far as we can see, from anybody to go back to the old way of listing 40, 50, 60 cases in a day and having tenants and landlords crowding into county courts, and each case, you know, going into court for 5 minutes and being sorted out in that way. At the same time, there is this desire on the part of landlords, and it would appear the government, to have a fast and, as they say, efficient possession process. So the group that was tasked to look at the overall arrangements and see how that should evolve is now tasked, in fact, to make recommendations as to what should happen next, what bits of the overall arrangements might be retained, whether there should be a massive wholesale reform of possession proceedings. Really, it's unclear to me what is on the table in this process, and yet we are asked to, HOLPA is asked, along with other representative bodies, to make recommendations to the Master of the Rolls, and through the Master of the Rolls onto the departments, Ministry of Justice, Ministry of Housing, Communities and Local Government. So without knowing really into what space we are pitching these recommendations, HOLPA's view was that we should set out some broad principles. that we believe are important for any changes that take place. So if you don't mind, I'm just going to run very quickly through them. I'm not going to go into the detail because that would be rather tedious, but I just want to go through the basics of the principles that we think are important. I'm interested to see actually if people on this call want to challenge those, and I'd be very happy for people to challenge them with, you know, good reasons. So I'd be very happy to hear about that in the discussion after. The first thing is that the civil procedure rules, although just like the overall arrangements, flawed, is actually a very tried and trusted procedure for dealing with possession claims. It's evolved over a number of years. It has case law attached to it. And in general, it broadly does justice between the parties, in my view, in and of itself. There are other aspects that mean that that justice can be curtailed, but the civil procedure rules in themselves, well, allow a process of law and a process of justice between the parties. The accelerated possession proceeding, where a judge can make a possession order without hearing from the parties, is perhaps not a shining example of that. But in other respects, though, the civil procedure rules is very apt for dealing with possession proceedings because it has specific parts that deal with possession itself, but also other rules and practice directions that deal with the other elements of a possession claim that inevitably follow with the possession claim itself, i.e. a basic contractual claim to do with money. It can deal with counterclaims concerning disrepair. There are rules that deal with enforcement. There are rules that deal with appeals. And so whatever happens in possession proceedings, the CPR is there, as it were, to deal with any of the possible outcomes. And so it's important for Holper, I think, to stress the positives of the CPR while recognising its weaknesses. One of the reasons why we want to do this is that there are moves afoot. Well, there are moves from other organisations, rather surprisingly, one called Justice being foremost, to take possession claims completely out of the existing court system. And have all claims dealt with by a judge sitting by themselves and not hearing from the parties. This is a scheme which, to my mind, must be resisted at all costs, really, and set alongside a scheme such as that. The CPR seems like an absolute, ideal system. There have been some things that have happened through the overall arrangements which are worth keeping. The landlords and lenders, in fact, are now required to basically put their case up front, and that was not the case. Remarkably, that was not the case before. So, while prior to March 2020, I might see anything between 10 and 20 tenants on a duty day. And go in and represent them in the court and try and prevent a possession order being made, I almost certainly would never have a full set of papers dealing with the tenancy agreement, the notice, a proper rent schedule. I mean, sometimes I would be able to make mischief with that fact, in fact. But in terms of advancing justice, as it were, the paperwork is an absolute shambles. The R bundle deals with that in that it puts all of the relevant documentation out up front. And if there are problems with the landlord's case, they can be identified quickly, put to the judge, and cases can be struck out or adjourned accordingly. So there are some innovations that are probably worth keeping. One thing we talked, I think Marina has talked about the low take up of duty advice, particularly on the R date. one of the things that's worth considering, it's a difficult one, this, but one of the things that's worth considering is whether it's possible for tenant and borrower-based duty advisors to be able to contact defendants in advance of possession hearings to offer duty advice, almost like a, let's call it a track and trace system, where duty advisors can try and offer that advice, and that may, well, that ought to really increase the numbers of people getting advice before they go to court. I think the next principle is about adjudication and mediation, and really this point sets out our really quite deep skepticism about mediation in a housing context. That's to do with the complexity of housing law, but I think more than anything, really, it's to do with the power imbalance between the parties in nearly all residential landlord and tenant cases, and also in mortgage cases as well. I think a person in a mediation who's at the lower end of a power imbalance, that mediation just simply cannot be fair. Again, one of the major disappointments is while the R date, which if you recall is an opportunity for tenants and borrowers to get advice from a duty advisor, while that's being taken out and shot, the mediation pilot, which has shown no real aptitude for dealing with possession proceedings, that's extended into March 2022. I wouldn't be surprised if it was extended again if need be, because there's simply a mania about mediation within government and within parts of the judiciary as well. I think both Marina and I were at a meeting where the judicial lead for alternative dispute resolution, Lady Justice Asplin, was present. And she was saying, oh, well, we don't call it alternative dispute resolution anymore. We call it dispute resolution because there's nothing alternative about it. That's worrying. I think that's a worrying thing. Next, data and monitoring. I mean, one of the things, again, that is terribly frustrating. I'm sorry it's such a gloomy talk, but this is where we are, I'm afraid, folks. Data and monitoring, it's become a trite thing to say that, oh, the pandemic has shone a harsh light on whatever. Well, one of the things it's shone a harsh light on is the fact that the data held by the Ministry of Justice on possession proceedings is absolutely woeful and really of very little use in determining, how any reforms should work, let alone the sort of reforms that have already taken place and are contemplated in the future. It's really important that the MOJ's data game is just that they get a data game, basically. If you want to do more reading on that, if you simply put into Google Dr. Natalie Byram, you'll come across a number of papers where she shouts at government basically about their lack of data collection and how they can't possibly do any kind of properly informed reforms without improving their data position. I just note that, for example, there was great work done, not due to the pandemic, but almost coincident with it. But there was great work done to put High Court enforcement of possession orders on an equal footing with county court enforcement. It's going to seem increasingly bizarre, this, but it used to be the case that if a landlord successfully transferred enforcement of a possession order to the High Court, there was no provision which meant that the tenant will get any notice of the actual date that they will be evicted. And High Court enforcement officers would often turn up by surprise because it would mean that they would more effectively be able to evict people. It was actually the case with County Court enforcements as well, but the county court did always give notice of the evictions. Anyway, now that's been reformed such that High Court enforcement officers must also give notice. But there is no monitoring of High Court enforcement activity. The MOJ can't say how many High Court enforcements there are. There's also no equivalent duty advice for people applying to suspend a writ of possession in the High Court, whereas there is in the County Court. And High Court enforcement is possibly as a result, but is certainly on the increase as the way for landlords to enforce their possession orders. This number 4 is titled No One Left Behind. This is really to do, I think, with digital innovation. And of course, digital innovation comes in a number of guises, but the two main ones, I guess, is to do with documentation. It's hard really to resist the idea that not having piles of papers, hanging around, falling over, getting lost, ruining the environment, apart from anything else, that digital innovation couldn't do something to alleviate that. However, it's really important that nobody gets left behind in any reforms that are made in that regard. There are still a very, very large number of people, many of them vulnerable, who will not be able to deal with digital paperwork, as it were, digital documentation in any setting, never mind a court setting, and those people must not be left behind. There have been worrying statements from the judiciary in relation to this about forging ahead and, not really worrying too much about apparently small numbers of people who can't deal with digitized paperwork. That's wrong. I mean, it's just outright wrong. The people who can't manage that are the people that we absolutely need to focus on, rather than the other way around. There's also the issue of digital court hearings, video court hearings. Again, there is just such a lack of data about how the digital environment for court hearings has an effect on the participants, on the judiciary, on the advocates, and how that plays out in outcomes. Surely there needs to be widespread and really deep studies done before there is a wholesale move towards digital court hearings. Lastly, this is the self-interested bit: sustainability of advice and representation for tenants and borrowers. I mean, our end of the sector is, well, it's impoverished, to say the least, by rates of remuneration under legal aid being just remaining static or going backwards for decades rather than years. The culture of decision making at the legal aid agency is poor, and many of you, I think, will be aware of the heat map produced by the Law Society in relation to housing law deserts, and that's just, it's just that's the signifier of the problems that our sector has. There are massive swathes of England and Wales where you cannot get housing law advice because there simply isn't a housing lawyer. Many people have left the sector. Young people are not coming into the sector. It's a real problem. So this is a situation that we find ourselves in, and we are asked, as I say, to make recommendations. We are asked to participate in what should happen next. We set out some broad principles there. As I say, I'm really interested in challenge of these. These are principles that we have tried to road test as much as we can, but we're working very much at speed, and we're working very much in a bit of a silo. So any kind of opinions I'm really interested in. So the last thing to say is to just try and bring this back to the topic as a whole. What happens to possession orders, evictions, and resultant homelessness? It is really difficult to say. Journalists have been asking Marina and I for a year and a half now, when the tsunami of evictions is coming, and Marina has been through the list of measures that have been taken, including, you know, staying possession proceedings, eviction bans, longer notice periods. None of it has got to the most important problem, which is rent arrears. There's been very, very little to virtually nothing on that. And those rent arrears are there. They are still in the system. The measures that have been taken are very, very analogous to the measures that are taken in relation to the pandemic itself. It's about flattening the curve. If we take the analogy further, possibly too far, but if we take the analogy further and see the homeless persons units of local authorities as being analogous to hospitals, the idea has been to flatten the curve of homelessness so that local authorities don't get overwhelmed. But there's been nothing of any substance. What there hasn't been is a vaccine. You know, if the vaccine is successful, then it will, you know, it will hopefully resolve the pandemic crisis. There's nothing like a vaccine in relation to particularly the private rented sector, but the rented sector as a whole. The measures that have been taken are like a leaky dam, it seems to me, and you know, they've let a trickle of possession orders and evictions come through, and then bits of the dam have fallen away, and the trickle becomes a stream, and then the trickle becomes a river, and at some point it will become, in my view, probably, this is a mug's game to try and predict this, but probably, I think, towards the beginning of 2022. By that point, I think the number of evictions will be very large, and it will be at that point that local authorities may well be becoming overwhelmed. In actuality, local authorities are already overwhelmed, and they were overwhelmed in February 2020. The housing lawyers on the call who do homelessness work will know that implicitly, and I can imagine you all having a rather dark, wry smile at me saying that they'll be overwhelmed next year. But that is, I think, where, you know, it may come earlier than that, but there will come a point where the possession orders being made and the resultant evictions will not be able to be mitigated by, there aren't any further measures coming that we're aware of, but it will be too late anyway if there were further measures, and that's when there is a possibility of the local authorities becoming overwhelmed, and it is very difficult to see how that's going to be dealt with. And I'm sorry that that's such a gloomy presentation, but there it is. And I would really now welcome discussion on the principles that we set out, the matters that Marina set out before, and look forward to talking to you about that now.
Thanks so much, Simon. Well, we asked you a gloomy question, and it's not your fault at all that you've given us a gloomy answer. There have been some questions come in. The first one, I think there was some talk in the chat, but I'm going to read it out anyway because there'll be a recording of this and not everyone will have access to the chat. And it's from Jackie. And Jackie says, how do we encourage renters to seek early advice? There are many technical and other defences and counterclaims which can be made at an early stage. If all else fails, some of us can attend mediation with tenants. So how do we encourage renters to seek early advice? And can I go to Marina first and then Simon?
Thanks, Nick. Thanks, Jackie. Sorry, I started to answer that question in the chat box until you're quite right. I think I realised it's been recorded. I mean, it's at the moment with the R date and the sort of second hearing, if you like, the S hearing, the only way in which tenants are being encouraged to seek early advice is by way of the letters that are sent out. And funny enough, just before this meeting, that was an issue in the meeting that Simon and I had in the working group, which is that that's simply not working. And so it doesn't matter how many letters you send out to tenants, they don't understand, because lawyers don't understand what this R date is really about. in essence, it was created to ensure that free early legal advice could be given, partly because the legal aid agency insisted on it as the only way in which they would fund early advice. So it was a made up date done by way of a listing arrangement, as opposed to anything under the CPR. And in fact, I remember the moment that I realised, and Simon and I realised, that there will be no changes to civil procedural rules to reflect the creation of this R date. It was simply a listing matter. So tenants don't quite appreciate that they are able to get free legal advice at the R date. And so getting the message across to them has been a problem. One of the things that were discussed, certainly Simon and I have discussed at great length, is whether or not duty advisors should have the power or ability to themselves contact tenants, and then one gets into all sorts of difficult issues about GDPR. When the R date goes, it's difficult to say how we should encourage, or how we can encourage tenants to get early legal advice, because we don't know whether in fact there will be early legal advice once the R date goes. We don't know if we're going to go back to a system where the only advice will be at the S hearing, i.e. the old type first hearings. We certainly hope, and that's been the basis of our discussions, that there will be some early legal advice in place of the R date. We don't know whether that will be the case, but we hope that will be the case. How we encourage tenants to then take up that advice, I don't know, because there will be no R date to sort of to link it to. There will be no R date to make a reference to. So how do you get the message out to tenants generally that there may be some non-means tested, and again, I don't know if that's going to be the case, but certainly what we're pushing for, some non-means tested early legal advice that isn't attached or associated with a made-up R date. That's very difficult, and I don't know what the answer is. Simon, I don't know if you wanted to expand on that.
All I can do is amplify that, really. It is really difficult. It's absolutely critical, though, because I said in my presentation that there is a mania for the mediation, and there is. It will just, I'm afraid it will just get an open door. And all that can be done in relation to the mediation, about which I'm extremely skeptical, not mediation in general, mediation in this context, but is to try and ensure that there is a piece of advice that precedes that mediation, so that if the tenant or the borrower has a defence, then that's identified, and that case does not go to mediation because there is a defence, and that's pursued in the court. That is really, really important, and that's the part of the R date, of the review date, that has been missed by the judiciary, by district judges sitting in their chambers going through papers, by, to be fair, lots of people, I think, on our side as well, because it was hard to understand. What we will have to do is find some way that there is some thought that the legal aid agency may fund a piece of early advice, but it has to be slotted in before. It has to be slotted in before the substantive hearing date, so before the case goes before a judge, and it has to be the gateway to the mediation that will be in place, so that it is the duty advisor that is the gatekeeper for the mediation, and cases that are not suitable for mediation are not going in that direction. That's going to be a massive challenge. One of the ways in which duty advice works is that it's a discrete piece of advice that happens on one day. So I can go to court knowing that on that day I'm at court, I'm seeing people, and that's my job to do that day. My phone is not available for people to call, and it works for I work for a for-profit high street firm of solicitors. It works for my firm in that they know that my time will be remunerated for that day, so they're not, that's fine. If there's a free floating piece of advice that's to be delivered over in a certain period of time, that becomes very, very difficult to manage. But that's actually the challenge that we, from our point of view, if we want to do a service to our clients, that's the challenge that we have to step up to and find a way of making that work. The other thing to say is that the early advice is all very well, but we're still in a situation where the early advice that we're giving on a lot of occasions is, well, you're facing a mandatory possession order. there's not a lot that we're going to be able to do.
Thanks for that, and it's a difficult question. I know Jackie said in the chat that there are funded organisations that do non-legal aid matters, and it is incredibly difficult to get that information out there. Even when you're looking for it, it's quite difficult to find. The one thing I would add, and this is a Labour Party meeting, so I'm not embarrassed about saying it, is that we need to take back to our communities, to our CLPs, that legal aid is still available for housing matters, and particularly if you're on passporting benefits. And just the more we say that, the more people that know that, the better.
I mean, just
Marina.
on that point, Nick, the court service can be doing more here, I think. I mean, again, one of the issues that we very briefly discussed at the meeting is how the court service can be doing more, or whether it should be doing more to give vital information to tenants. So, you know, duty advisors cannot contact tenants. There's all sorts of GDPR issues there, but query whether or not the court service, when sending out papers from landlords and so on, should, along with those documents, be putting leaflets in or whatever it may be, saying there is this free legal advice. So there was so much discussion about the letters that should be going out to tenants, advising them about the R date. There was a lot of time spent on that. There was a lot of time spent trying to convey the message that it was important for people to make contact with duty advisors, and at that point they would get advice, but don't worry, no possession order will be made on that date. That was a difficult message to convey, and there was a lot of discussion about how we should do that. There could be some room, I think, and there's not been that much discussion. There's been some discussion on this about whether or not the court service can, along with the claim form and everything else that goes with it, send out some information simply saying you can get free legal advice by contacting this organisation or whatever it may be. So not linking it to an R date, not advising the tenant they should make contacts, really important, big bold letters and all the rest of it, simply putting the message across about free legal advice.
Thanks. One quick point on this and then we'll move on, but it seems to me that this is exactly what the old prescribed information on notices to quit was designed to achieve, but it's now hopelessly out of date. And maybe one thing that HILP could be pushing is for a statutory instrument to amend the prescribed information to say this is how you get advice in the 21st century.
Nick, we're always looking for people to draft for us, and thank you for stepping up there.
Nothing pleases me more than drafting statutory instruments. There's a technical question from David, and it's about how accelerated possession proceedings interact with the review date. Is there a review date if the landlord brings an accelerated claim under Section 21?
There can be. There doesn't have to be. Judges will often use it as a way, as David knows better than anybody here, the requirements of a Section 21 claim are now labyrinthine, to say the least. And judges, I think, use the judges that do use it use the review date as a way of almost outsourcing the investigation as to whether those requirements of Section 21 have been met. That sounds a bit craven, but actually, in some ways, it makes a lot of sense. If you're a district judge sitting in Romford County Court, you might have to have intimate knowledge of the wards of the town of Ilford in order to know whether those particular wards are running the selective license scheme or not. It's impossible, actually, for a district judge to have a really 100% solid way of assessing an accelerated possession claim. And so the more enlightened of them use the review date as a way of trying to get advice for people in order to try and get some of those issues bottomed out, because they know that a duty advisor will hunt those issues down and will make them make that information available to the court. But it's not mandatory, David. It's not. It doesn't. It's at the judge's discretion when they consider the papers in the normal accelerated possession way. If you see what I mean.
Thanks for that. I've had a question asking whether judicial attitudes towards arrears have changed. And if I can just expand on that, I think when you get to know district judges well, you find out that they have a magic figure in their head, above which there is no hope, below which there is some scope. And in your experience, has that number changed dramatically in the last year or so? Can I ask Simon, then Marina?
There's not been the opportunity really to find out, because the cases that have been going through are extraordinary in a number of different ways. The two main ways are there's been very little local authority possession cases, and even not much, although a little more, but not much housing association possession action either. And those are the cases generally where there is discretion for the judge to look at the level of arrears and decide what she is going to do. The majority of the cases, as I said before, and I'm really sorry to be gloomy about this, but the majority of the cases are arrears in the tens and thousands of above, in private renter cases where the landlord has a mandatory ground for possession, and so the judge doesn't have any discretion to look at the level of arrears. The only figure they're interested in is 2 months, whether there's 2 months arrears at the date of the notice and 2 months arrears at the date of the hearing. And so, yeah, we don't really have any sense of that. That kind of changes over time anyway. When I used to go to the old Shoreditch County Court in Leonard Street, there was a district judge there who would say £15,000 will Hackney, it was usually Hackney. Hackney, how have you let it get to this point of £15,000? I'm not going to make a possession order. It's your fault. Adjourn the case. That doesn't happen anymore, I'm afraid.
Thanks, Marina.
I mean, I agree with Simon. I haven't really seen all the possession matters I've been involved in recently have been antisocial behaviour cases, and I can tell you judges have not changed their attitude towards those. So I can't add much more, I'm afraid. Thanks.
There's a question, and I think it's a really interesting one.
Sorry, can I just say one more thing about that? Judges are, I don't know if they're more so. I think on balance they probably are. They are more willing to take, if you can find that technical point, they are more willing to take it, because I suspect that judges are sick of making possession orders as well. Sorry, just a very quick point.
No, that's worth knowing. Thanks. Given the year we've had when people have been trapped inside their homes under very, very difficult circumstances, do you think there's an extent to which people are giving up their homes more willingly? And that's partly why we're not seeing so many claims as we thought we would. Can I take Marina and then Simon?
Yeah, absolutely. It's the hidden number. And not only are people giving up their homes more willingly, I was reading an interesting article in The Guardian, for enough, that was saying people, something like 50,000 people aren't claiming universal credit because they're embarrassed, because they're fearful. So these are the hidden numbers, and this is one of the concerns about mediation. How do you assess the strength of the mediation? Are people willingly giving up their homes? And in those circumstances, are they setting themselves up to fail when it comes to future homeless applications, because they will be considered intentionally homeless? I mean, it's potentially a real disaster, and I think that is happening. People are giving up their homes because they recognise that they haven't paid their rent, and they believe that they don't have defences, and they probably recognise they haven't paid their rent in circumstances where they may have been able to have paid it a year ago. Do you know what I mean? It's a very new thing for them. So I absolutely think that there is a huge number of people giving up their properties, and it's the hidden statistic, and it contributes to why perhaps we have not seen the tsunami of evictions over the last year.
Thanks, Simon.
Not much to add. Marina's been doing some amazing work looking into this with our friends at Safer Rent in Cambridge House, who are an extraordinary organisation doing really interesting work with in relation to, as it were, the rogue private rented sector. But for all the good work that they're doing, there needs to be a lot more information, a lot more studies, I think, about what actually happens in the private rented sector, particularly at the lower. I mean, no rents are low, but at the lower rental end, where it's you know, it's the Wild West out there.
Thanks. And then last question, because we're just coming up against the hour, and it's how bad is the backlog? if my landlord is intent on evicting me, do you have any sense of how long it might take, given how many cases have got to come through the courts?
I think once it's in the, go on, Simon, you go, Simon.
Yeah, it's a bit random. It's a bit,
Yeah.
it's a bit random. I've had cases where I thought, oh, nothing's happening on that. And then suddenly you've got a hearing coming up next week. So it's a bit random. And obviously as a duty advisor, so a lot of the time, and sadly, because I'm, you know, I'm overseeing these possession orders being made all the time. And people want to know, well, when, you know, how long have I got? So I do the explanation about you don't have to leave on the date of the possession, but well, you know, when are the bailiffs going to turn up? It's really, really very hard to say. There are various prioritizations were meant to have been going on. That didn't really happen, and I think I think it's really random. There isn't the numbers of there still isn't the numbers of cases coming through, and part of that is a self-denying ordinance, I think, on the part of local authorities. Some social landlords, not all of them, but on some. So there isn't the kind of, despite the low levels of cases going through, there isn't the massive clogging that I think we thought we'd see. But again, the data is a bit opaque. I'm afraid I haven't really, there is data available, but I haven't had the chance to really kind of go through it with a fine-tooth comb. But even when you do try and do that, it is quite opaque to try and understand what might be in the system. And I think, you know, the MOJ sort of admit that openly, which is a bit disgraceful, really.
Yeah, I mean, I'm certainly getting not so much possession final hearings, but I'm seeing quick turnarounds on hearings generally. In my experience, Nick, you may have the same experience. So whatever it may be, whether it's CMCs or whatever it may be, I'm seeing quick hearings being listed quite quickly.
That's interesting. Thanks. Well, I think that's about as much as we've got time for. So thank you so much to Simon and Marina. They've really got their finger on the pulse better than anyone else does, and it's been brilliant to have their wisdom and experience, even if some of the answers have been gloomy and indeed frightening. And thanks also to Joe Vincent for running the tech tonight. I'm really, really pleased that so many of you came along this afternoon. It's such an important topic. We're facing such a frightening prospect over the next few months. So sharing our expertise and knowledge and commitment to keeping people in their homes is just so important. These webinars, these housing webinars, are running just about monthly at the moment. So please do keep an eye on your inbox for upcoming events. And otherwise, thanks very much for coming and have a nice evening.